The EFF believes that not only did Watchtower only respond to certain things, only responded to a limited number of the problems that the EFF raised in their motion for reconsideration, that they did so in an untimely fashion. And by not raising objections to some key facts, they basically admitting the key facts, and those key facts then can be operative and also be used against them.
This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below.
So you may remember this case from such episodes as Watchtower requests Darkspilver's information, Reddit refuses Darkspilver's information, EFF gets involved, Watchtower requests Darkspilver's information, and so on and so forth. This is the DMCA subpoena to Reddit. This is the motion for reconsideration that was filed because the EFF basically won almost everything that they wanted, except Darkspilver's identity was still going to be turned over to Watchtower's attorney under attorney's eyes only orders. Now, it's a very interesting sort of situation, because on one hand, we know that Paul DiPolidoro, Watchtower's attorney, has some sort of loyalties to Watchtower, Jehovah's Witness, to his God. And that should really not conflict with his duties to the court. But this weird situation has now come up where he is both loyal to his religion and he is an officer of the court, and the court is entrusting him as you would with one of your officers. Think of an officer in the military. You would give them orders and entrust them to fulfill the orders, and it would be a rare thing that the officer did not carry out your orders. And that officer can be removed from duty if they do not carry out your orders. This is not the military. We're not giving people orders to conduct military operations. We're giving people orders to conduct court operations. And Paul DiPolidoro is an officer of the court, is a person who is just as responsible to the court as they are to their client. And then the question becomes, are they so loyal to their religion that they would violate these other duties, these earthly duties to the court as an officer? And of course, there are doubters. And I don't have any basis. I don't have any fact to say one way or the other. I have my personal doubts, but I'm not going to let them cloud my objective judgment that I have no idea whether Paul DiPolidoro really would violate the court's attorney's eyes only order. But we don't get that far yet. Reddit has still not released Darkspilver's identity because the Electronic Frontier Foundation, Alexander Moss, and I believe there's one other attorney attached to this now, have filed a motion for the judge to reconsider the order for attorney's eyes only, saying that if we found all these things to make it attorney's eyes only, well, what's the point of attorney's eyes only? It's actually supposed to, the facts and the law operate. If we found these facts to be true, then the law operates that attorney's eyes only is a bridge too far. And we actually want to back off of attorney's eyes only and just deny the whole thing. So the EFF is basically doubling down, saying that they want the subpoena and the identity, they want the subpoena quashed, the subpoena vacated, and the identity protected, even against attorney's eyes only, because they don't really trust that even attorney's eyes only is going to be enough. And I happen to agree with them, not because I think the identity is going to be misused. I don't have any reason to believe that. However, the identity shouldn't be given in the first place. The chart is not a copyrightable thing, and at most, the Watchtower organization has some kind of claim that a mole has leaked information, that an insider has leaked inside confidential information. And unless there's a confidentiality agreement or some law that prevents them from leaking the GDPR chart, then that's not any legal violation. So we can't get to Darkspilver that way. Now, the flyer could be a copyright violation, but it's really close to not a copyright violation. It's the back page of a magazine, the very same case that Watchtower cites as saying that a page of a magazine can be the heart or entire magazine, is for an inside page and for content that goes to the heart of the magazine, so it's core content. Whereas the back page or front cover of a magazine are very visible and are often used to advertise or sell the magazine or both. And so that's not as protected. So at that level, even that magazine back page isn't really it's not a copyright violation to republish that and say, hey, look at the back page. Now, would it have been more of a fair use if there had been a big commentary, look at how Jehovah's Witness uses the back page of their magazine, I disagree with this, I think this is such and such and so and so. That would have been much closer to commentary. So is it fair use just to post it on Reddit and have others comment? Does Darkspilver need to comment on the original post? Does he need to, or she need to comment in the comments? Does it need to be like in the description? We don't really have those answers. So I don't think I still don't think that reaches a level where a subpoena should overcome Darkspilver's privacy interest in this particular case. Maybe if there was no connection to the organization, if it was some third-party organization that Darkspilver is not in, but the accusation on the EFF side is that this is more like a mole or witch hunt, an insider leak hunt. They're looking for the person who's leaking inside information and using copyright to do it. So let's take a look at what the EFF's... Okay, so where are we? The EFF has filed the motion for reconsideration. Watchtower has filed a response saying, no, you shouldn't reconsider, and they sort of doubled down on their case that this was all massive copyright infringement and religious doctrine, and you don't get involved in religious doctrine. I believe the word heresy was used. Go watch our video on that. Now this is the last, final response from the EFF before the judge will rule. And we're going to go over the entire thing. I have not read every word of this myself, but I can basically guarantee it's going to be very interesting. So listen up. So here's their table of contents. And you know what? It'd be very nice to read all of that, but we're going to skip ahead because we're looking at all this anyway. Watchtower's references to Doe's reputation as a leaker confirm that its interest in uncovering Doe's identity has nothing to do with enforcing its copyright. The only copyrighted or copyrightable material at issue in this case is the back page of Watchtower's monthly magazine, which it makes widely available for free, online and in print. Watchtower cannot seriously believe this image was leaked. If Watchtower wishes to learn Doe's name because of its concerns about leaking, it may have viable legal options for doing so, but the Digital Millennium Copyright Act is not one. Watchtower fails to address many of the points raised in Doe's motion for de novo determination, which I'm calling a motion for reconsideration. The name of it might not actually matter too much, but they call it a motion for de novo or brand new determination. Instead, raising a host of its own untimely and improper objections. Watchtower particularly does not address the objection to disclose to in-house counsel, giving no reason why this case should be treated differently from other intellectual property cases in this district where the model protective order prohibits such disclosure. Although Watchtower's late and vague objections should be disregarded, they are also meritless. Judge Kim correctly concluded that Doe's motion to quash is timely. The First Amendment applies to Watchtower's attempt to force a U.S. company to disclose a user's identity by invoking a U.S. court and law. Watchtower's unregistered chart of legal compliance information is irrelevant. Forced disclosure would harm Doe, and all four fair use factors show that Doe's use was fair. However emphatic, the assertions of Watchtower's counsel are not enough to satisfy the test for unmasking anonymous speech on matters of public concern under Highfield's Capital Management v. Doe, a 2005 Northern District, California case. Holding otherwise would irreparably harm Doe, and the precedent it sets will irreparably harm the public as a whole by deterring others from speaking openly about Watchtower's publications, thus depriving the public of valuable information and views. The vast majority of internet users will not be able to retain pro bono counsel or afford private counsel to defend themselves against DMCA subpoenas such as this. Judge Kim erred in failing to consider the chilling effects on speakers other than Doe when considering the consequences of compelling Reddit to reveal their identity to Watchtower's in-house counsel under these circumstances. If allegations as baseless and implausible as Watchtower's can pierce an online speaker's anonymity, despite overwhelming evidence of fair use, it will become even more difficult and more costly for people to preserve their anonymity when they speak out about powerful organizations with the means to obtain and enforce subpoenas such as this. So then they go on to argue more about de novo review. Judge Kim's decision requires de novo review by this court pursuant to 28 U.S.C. 636b1 because it disposes of the sole issue in the case and terminates the action. Watchtower concedes that Judge Kim's order was dispositive, and then they cite to their opposition at paragraph 7 to 8. Because they are dispositive, both DMCA subpoenas and non-DMCA subpoenas are subject to de novo review by the district court. Watchtower nevertheless contends that the direct appeals procedures of 636C apply instead. So they're getting into kind of the nitty-gritty of federal rules of civil procedure. So just try to sort of keep up, and you'll kind of get the idea by the end of it. 636C provides that upon consent of the parties, a full-time magistrate judge or part-time magistrate judge who serves as full-time, etc., may conduct any or all proceedings in a jury or non-jury civil matter and order the entry of judgment when specifically designated to exercise such jurisdiction by the district court or the court he or she serves. On its face, that provision does not apply here, where there was no jury or non-jury trial, no issue that could be tried. If a single motion hearing could qualify as an entire course of proceedings, 636C's application would be virtually limitless. No authority supports that approach. 636C also does not apply because the requisite consent is absent. Watchtower relies heavily on Roll v. Withrow, but the Ninth Circuit has interpreted Roll very differently than Watchtower, explaining that the decision does little, in at least a case such as this, to diminish our precedent's stringent requirements that litigants clearly indicate their consent and that such consent be voluntary. In Roll, the parties clearly implied their consent when they voluntarily participated in the entire course of proceedings before the magistrate judge and voiced no objection when, at several points, the magistrate judge made it clear that she believed they had consented. Here, in contrast to Roll, Doe did not clearly consent to the magistrate judge's jurisdiction for all purposes. In Roll, the respondent received notice and an opportunity to object, that's due process, to the magistrate's jurisdiction before the judge proceeded to adjudicate the merits of their claims at trial. The issue was whether their silence could imply consent when they had received notice and an opportunity to object and failed to object at any time. Under those circumstances, the Supreme Court held that consent could be implied. The court hardly endorsed an expansive view of implied consent. It merely rejected the Fifth Circuit's blanket rule against implied consent, concluding that the better rule is to accept implied consent, whereas here the litigant or counsel was made aware of the need for consent and the right to refuse it, and still voluntarily appeared to try the case before the magistrate judge. Nor do the local rules require written consent or declination for magistrates to conduct proceedings such as this. On their face, the local rules condition the requirement of written consent or declination on the date of the initial case management statement, a non-existent date in this case, which is just a subpoena enforcement proceeding and not a civil action requiring discovery and trial. The same is true for Judge Kim's standing order, which cites the same inapplicable rule conditioning compliance on the occurrence of events that cannot occur in this type of proceeding. Watchtower cannot rely on those provisions to avoid this court's review. Now on to the First Amendment claims. Courts routinely apply the First Amendment to foreign speakers in court proceedings affecting speech available to U.S. and international audiences. And they have a few citations there that I'll skip. Applying the First Amendment to foreign speakers, because remember, Darkspilver has admitted that he is not in the U.S., and Watchtower has said, oh, well, wait, the Constitution doesn't apply to him then. And that's not true. The First Amendment does actually apply to foreign speakers. Here's why. Applying the First Amendment to foreign speakers is necessary because the First Amendment not only protects the right to speak, but also the right to access the speech of others. As the Ninth Circuit has explained, quote, the First Amendment interests in this case are not confined to the personal rights of the journalists. Although their rights do not rest lightly in the balance, far weightier than they are the public interests in First Amendment freedoms that stand or fall with the rights that these witnesses advance for themselves. The freedom of the press was not guaranteed solely to shield persons engaged in newspaper work from unwarranted government harassment. The larger purpose was to protect public access to information. Given the goal of protecting public access to speech, quote, the rights of readers are not to be curtailed because of the geographical origin of printed materials. The First Amendment's protections for U.S. audiences would become practically meaningless if the foreign origin of a publication were enough to permit the government to restrict access to its contents. At the very least, foreign speakers must be able to invoke the First Amendment to protect privileged information, such as an anonymous speaker's true identity, sought in U.S. court proceedings initiated by U.S. entities for the sole purpose of violating that privilege. Judge Kim found that the subpoena here was issued by a court in the United States on behalf of a United States company and was directed against another United States company. A substantial number of U.S. residents subscribed to the XJW subreddit, and Reddit, a U.S. company whose compliance Watchtower is trying to compel, has joined Doe's motion. Judge Kim thus concluded that based on the involvement of the United States court's procedures by and against United States companies, and for an audience of United States residents, as well as the broad nature of the First Amendment protections, the First Amendment is applicable here. That conclusion is correct and consistent with the authority above. Civil Rule 72-3A requires that a motion be made pursuant to local rules and must specifically identify the portions of the magistrate judge's findings, recommendations, or report to which an objection is made and the reasons and authority therefore. Now, this sounds complicated, but listen up. This is going to be an epic smackdown right here. Doe complied with that rule, identifying its specific objection to the decision to order disclosure to Watchtower's counsel in this case, who is also in-house counsel for Watchtower. Watchtower, however, failed to address or respond to Doe's objection to disclosure to Watchtower's in-house counsel. Watchtower apparently does not dispute Doe's position that confidential information, such as Doe's name, should receive the same protections found in this district's Model Protective Order for Intellectual Property cases. Given Watchtower's insistence that it desires to pursue a legitimate copyright claim, it should be required to comply with this district's standard rules in such cases. Watchtower contends that Doe has not proven disclosure will harm them because Doe has not provided evidence they are a Jehovah's Witness, have friends or family who are Jehovah's Witnesses, who have seen firsthand people who openly question or disagree with Watchtower's practices and publications suffer social disparagement and retaliation in their community. But Doe has provided a declaration attesting to those facts and articles substantiating their experiences and observations. Declarations of this type were sufficient to prove harm in both Art of Living and Signature Management. That Doe has not identified another target of Watchtower's subpoena who has been formally disfellowshipped is irrelevant. Doe's concerns include social disparagement and ostracization, not just the ultimate act of disfellowshipping. The articles submitted by Doe confirm that those who openly question and doubt official practices and teaching suffer such disparagement and retaliation. Watchtower does not argue that conduct of the type it believes Doe has engaged in would spare Doe exposure to these well-reported harms. Somewhat confusingly, Watchtower asserts that disfellowshipping is not a harm and that it cannot disfellowship Doe. but Doe can reasonably rely on the part of Watchtower's website which states, if, however, a baptized witness makes a practice of breaking the Bible's moral code and does not repent, he or she will be shunned or disfellowshipped. And this is something that's on jw.org, and including June 20th, 2019 as an access date. Regardless, Watchtower does not dispute its ability to communicate with and or control those with the ability to disfellowship Doe or initiate proceedings that might lead to that end. Whether Watchtower views disfellowshipping as harmful is irrelevant. What matters is that Doe, likely many others as well, does. Watchtower's insinuations substantiate Doe's belief that disclosing their identity to Watchtower will lead to disparagement and retaliation apart from the ultimate act of disfellowshipping. For example, Watchtower invokes examples of other infringers reputed to be a key source of leaked information, and points to Doe's supposed reputation as a prolific leaker of Jehovah's Witness information. But leaking and theft of confidential information have nothing to do with copyright infringement. This court has expressly forbidden Watchtower from using any information obtained in this proceeding to determine how Doe obtained any supposedly confidential information in the chart. As Judge Kim made clear, Watchtower claimed at the hearing that it plans to disclose Darkspilver's identity to its forensic experts so that Watchtower can determine how Darkspilver obtained confidential information in the chart and prevent further disclosure of that confidential information. This purpose is not related at all to a copyright issue, and for that reason the court rejects that form of disclosure. That Watchtower continues to reference its use of information about infringers in connection with alleged sources of leaked information strongly indicates, to Doe's great concern, that Watchtower seeks Doe's name for reasons unrelated to copyright enforcement. And then here's where we're getting to that epic smackdown. Watchtower's objections are untimely. Quote, if a party believes that a magistrate judge has issued an order that disposes of a claim or defense, a dispositive order, the proper approach is to file a timely motion for review and or objection, which addresses the proper standard of review to be applied to the magistrate's decision as well as the merits of this challenge. Watchtower, however, did not file any motion challenging the magistrate judge's decision before filing its opposition. To the extent Watchtower raised new objections in its opposition to Doe's timely motion, those objections were untimely. To be timely, objections must be filed within 14 days of the magistrate judge's order. From 636B1C, quote, within 14 days after being served with a copy, any party may serve and file written objections to such proposed findings and recommendation as provided by rules of court. Watchtower waited until another 14 days after the deadline for objections had passed to raise any grounds of disagreement with Judge Kim. The general rule is that a litigant may not sleep on his rights and decide well after the deadline to challenge the order in any way to raise a belated challenge to a court order. By failing to object on a timely basis, Watchtower waived its right to object to the magistrate's finding of fact and contributed to a finding of waiver of the magistrate's legal conclusions as well. Watchtower's failure to raise or notify Doe in any way of its objections until after the deadline set forth in the federal rules expired should thus preclude their consideration in connection with Doe's timely objections. This error is not harmless. Doe, unlike Watchtower, will not have a full and fair opportunity to oppose its adversary's contentions with the full 14-day time period and 25-page limit for research and drafting. Given the pro bono nature of Doe's legal representation in this matter, Watchtower's gamesmanship is particularly prejudicial and should be strongly discouraged in this and future cases. Maybe that last sentence is getting up there a little bit. Timing aside, Watchtower also failed to comply with this district's local rules. The rules require parties to specifically identify the portions of the magistrate judge's findings, recommendations, or report to which objection is made and the reasons and authority therefor. Watchtower failed to indicate which of the magistrate's findings it specifically contests, as set forth below. This leads to much confusion. Watchtower's untimely and improper objection should be disqualified from this court's consideration altogether. Even if this court were to consider them, it should still reject Watchtower's objections. Watchtower does not dispute Judge Kim's finding that Watchtower has not demonstrated any actual harm or likelihood of future harm. Instead, it contends that it does not need to show such harm or likelihood thereof because courts permit parties to rely on speculation about the possibility of future events. But the case they cited, Disney Enterprises versus VidAngel, a case we're about to go over as well next. Disney Enterprises is a far different case, and the presumption of harm employed there is wholly inappropriate here. The defendant's conduct in Disney Enterprises was not a single posting of a screenshot of a free magazine's back page. It was a commercial screening service that offered more than 2,500 movies and television episodes to its consumers using digital decryption, reproduction, streaming technology. Moreover, because the district court concluded that VidAngel's use was commercial and not transformative, it presumed likely market harm and did not require evidence to prove it. Doe's conduct, in contrast, does not justify Watchtower's reliance on speculative assertions about harm it has repeatedly failed to substantiate. Watchtower asserts that diversion of web traffic away from jw.org could constitute market harm, but does not attempt to explain why it needs Doe's name to determine anything about traffic to Watchtower's own website. As Doe's motion argues, information about visitors to Watchtower's website is already in Watchtower's possession, not Reddit's or Doe's. Moreover, Watchtower bears the burden of showing with actual evidence that the balance of harms under Highfields justifies forcing Reddit to disclose Doe's name. To meet that burden, it is not enough for a plaintiff simply to plead and pray. Allegation and speculation are insufficient. In disputing Judge Kim's finding of fair use, Watchtower ignores Doe's comment on the ad, even though it was in the title of Doe's post. Doe's comment was a rhetorical question, guess what, in response to the question the ad posed. What gift should you give Jehovah? It is hard to imagine a more direct comment than that. The comment supports the finding that the whole post was in fact commentary. The argument that Watchtower needs discovery to determine if Doe's posting generated a profit is implausible. Doe posted a screenshot of the back page of Watchtower's magazine on Reddit. Reddit does not charge people to view posts such as Doe's, and nothing in Doe's post provided any information that would allow them to pay Doe. The only entity that could have earned money from Doe's post is Watchtower, as Doe's post included text in the ad directing people to jw.org and telling them how to donate to the organization online. Doe's use of the ad could not possibly have profited Doe. Watchtower does not object to Judge Kim's conclusion that it failed to present a prima facie case of copyright infringement with respect to the chart, though it criticizes that finding. To the extent such criticism forms an objection, it should be rejected because nothing in Watchtower's opposition casts any doubt on Judge Kim's conclusion. Critically, Watchtower did not present any evidence to support its claim of ownership, no registration certificate or other evidence such as a declaration from whoever made the chart supporting its assertions of originality and creativity. Thus, in the absence of any supporting evidence, the court found no basis for copyright ownership. Judge Kim is correct. Watchtower's assertions alone cannot support a cognizable claim. For the foregoing reasons raised and the reasons raised in Doe's motion for de novo redetermination and in their motion to quash, Doe respectfully requests the court quash Watchtower subpoena to Reddit in full. Alexandra H. Moss and David Green for the Electronic Frontier Foundation. And that was filed June 21st, just 2 days ago. So we will now get, I believe it's whichever judge is in charge of the case above Magistrate Judge Kim is probably going to rule on that. I honestly don't know. That's a good question. That's a good question, Leonard. Thank you. Thank you. Let us know what you think in the comments below. So basically what happened there, the EFF believes that not only did Watchtower only respond to certain things, only responded to a limited number of the problems that the EFF raised in their motion for reconsideration, that they did so in an untimely fashion. And by not raising objections to some key facts, they basically admitting the key facts, and those key facts then can be operative and also be used against them. So we'll see what the judge thinks about that. I'm still firmly on the side of the EFF and Darkspilver that Watchtower is phishing. and that we shouldn't allow our blessed copyright law to be used for a fishing expedition. In the same way that Jehovah's Witnesses wouldn't want us to use their religious doctrine, in an improper way against them, you're using our copyright law in an improper way against us who hold the law sacred. My lawful masses. So that is our show, everyone. Thank you for joining me. I am Leonard French, your favorite copyright attorney, dog lap sitting attorney on your stream here. And you are my lawful masses, and I really appreciate all of your support on patreon.com/ljfrench and sponsors.org/law. We have our short URL now, so thank you very much for that. At the $50 level, thank you very much to our supporters for the month of June: John Steele, Gavin Barnard, Kyle Mudrak, Eevi, Michael Pearce, Terry Crisp, Richard Fournier, Spirit Bear, Jan Negrey, Daniel Perez, Aspernari, and Snorre Wisotzky. And thank you to the $5 plus supporters that are scrolling on the LED panel behind me and will be in the description below. So that is our show. We'll leave some time for the editor to put some more outro video here because we like to share. So love you all. Have a great week, and I'll see you on the next stream, hopefully with Kaylee, and we'll have a good time there too. So love you. Have a good day. Bye.